I'm going to introduce all of you to section 56 of the Contract Act, which is one of the most important section in the present day context. It deals with the doctrine of frustration. As you all know, in the present pandemic and COVID situation, many of the contracts are getting frustrated because of the current pandemic situation. The origin of the doctrine of frustration, as many as other laws, have been originated from the Roman laws. And it was the Roman law of contract which introduces us to the doctrine of frustration before it was introduced into the Indian Contract Act and the English Contract Act. The entire scenario was during the Roman law, during the Roman period, there were a lot of the slave system was in vogue. So when there were trading in slaves, and at the time of delivery of these slaves to the owner by the agent, if the slave dies, then the entire contract becomes frustrated. So this is how the entire origin started from the Roman law. Then centuries later, in England in 1863, in the case of Taylor versus Cardwell, it was held when an opera house was rented for conducting certain meetings or certain concerts, and the entire opera house was burnt down. The doctrine of frustration was invoked in those situations. So in these circumstances, it was also held that the doctrine of frustration had its origins in certain situations which prevented the contract or the parties to the contract from enforcing the contract. Then down the line, in 1903, in the case of Paradine versus Jane, it was held that in common rule of contract, a man was bound to perform his obligations which he had undertaken and could not claim to be excused by the mere fact that the performance had subsequently become impossible, because the party would expressly provide in their agreement the fulfillment of a condition or the occurrence of an event. So these are the very basis on which the contract of frustration or the doctrine of frustration was coming into vogue. Secondly, the next case of Krell versus Henry in 1903, when an Englishman named Krell wanted to rent an apartment to witness the procession of the king. He had made some advance payment to the owner so that he can see the procession from the balcony of the apartment. So on that particular day, when the procession was supposed to take place, was cancelled, Krell refused to pay the balance money, saying that since the contract could not be fulfilled, in view of the cancellation of the procession, I will not be making the payment. It went to the court, and the English courts held that the procession, being the basis of the contract, was frustrated since the procession could not take place. Hence, the landlord cannot claim the balance amount of rent from the tenant, that is Mr. Krell. So this was the development of the doctrine of frustration. Now, coming to the doctrine of frustration vis-a-vis the Indian Contract Act, Section 56 of the Indian Contract Act introduces us to the doctrine of frustration. Now, Section 56 states that when the agreement, the heading of that Section 56 is agreement to do an impossible act. An agreement to do an act impossible is void. So if you're mentioning certain facts in an agreement which is impossible, then the agreement itself becomes void. So this is the doctrine of frustration, Section 56, Part 1. Part 2 is contract to do act afterwards becoming impossible or unlawful. A contract to do an act which after the contract is made becomes impossible or by reason of some event unlawful, then it becomes a void contract because of the impossibility or the unlawfulness. So this is the second aspect of the section 56. The third part of section 56 is compensation for loss through non-performance of act known to be impossible or unlawful. So this is one of the important parts of section 56 which provides for compensation even if the act is impossible or unlawful. Where one person has promised to do something which he knew or with reasonable diligence might have known and which the promisee did not know to be impossible or unlawful, such promiser must make compensation to such promisee for any loss which such promisee sustains because of the non-performance of the promise. So this is one aspect which introduced the component of compensation to be paid by the promisor to the promisee for the since the promisee does not know about the impossibility or unlawfulness of the contract which was within the knowledge of the promisor. For example, A agrees with B to discover a treasure by magic. This agreement is void because it is impossible right from inception. Nobody can create a treasure from magic. The second aspect, which is also very prevalent in these days, is A and B contract to marry each other, and before the time fixed for the marriage, A goes mad or becomes insane. The contract becomes void. So these are the some of the illustrations of the doctrine of frustration, which the students and also the audience who are not exposed to the legal jargons will be easy to understand with these illustrations. Now the third aspect, the other illustration which I would like to bring it to your or highlight is A contracts to marry B, who's already married to C, and being forbidden by the law to which he practices the doctrine, the polygamy. So A must make compensation to B. So the third part of the contract is the compensation. Suppose it is within the knowledge of A that B is already married, and then in that case he has to pay a compensation to B for the loss caused to her by the non-performance of his promise. So these are the third component of section 56. The other illustration is A contracts with B to carry a cargo to a foreign port. Then what happens is the government of that country declares a war against the country from which A is exporting. So the contract becomes void when war is declared. So the other aspect is, suppose A is transporting some cargo to B at a particular place, and there is a fight between these two countries, which makes the entire contract void. So this is the other definition or the explanation to highlight the frustration of a contract. So these are the basic illustrations to highlight what is the doctrine of frustration. Now the next thing is, the section also clearly mentioned does not apply to a case in which the consideration is lost. The consideration is lost, the performance is still possible. So these are some of the highlights of the doctrine of frustration, where even if the consideration is lost, the performance does not become impossible. So these are some of the highlights of the doctrine of frustration or the historical background of the doctrine of frustration. Now, the doctrine of frustration is also important, is a special case of the discharge of the contract by impossibility to perform it. The Indian Contract Act, as you know, does not define what is frustration. However, the Black's Dictionary defines frustration in relation to contracts as the doctrine that if a party's principal purpose is substantially frustrated by unanticipated changed circumstances, that the party's duties are discharged and the contract is considered terminated, also termed as the frustration for the purpose. In India, the courts, the expression in India, the courts have very clearly explained it's an elliptical uh, expression. The fuller and more accurate expression of frustration of the adventure. It's called the frustration of an adventure or a commercial or a practical purpose of the contract. This doctrine is a device to reconcile the rule of absolute contracts with a special exception, which is demanded in certain circumstances in name of justice. Now, coming to the doctrine within the purview of Section 56 of the Contract Act, it is discharges the contract by reason of a supervailing impossibility or illegality of the act agreed to be done. So this is to explain it in a very simple term. If a contract envisages certain duties to be performed and there is a supervailing event which is outside the scope of the contract, preventing the parties from performing the contract, then such a contract can be deemed frustrated or terminated. For example, there is a pandemic which is not envisaged, then the contract is suspended till the pandemic prevails. Suppose the contract envisages a situation and there is a war between two countries which makes the contract, if it is a time bound contract, impossible, then the contract is terminated. So this is the few basic examples of the doctrine of frustration. Now, the doctrine of frustration is envisaged in section 56 of the Contract Act. Similarly, there is another provision which also envisages frustration, but which is a little slightly different from section 56 of the Contract Act. That is section 32. Section 32 is very important because that is which deals with contingent contracts. That is contracts which is based on certain things to be performed and which is envisaged within the contract. Okay, so section 56 is envisaging factors outside the contract. Section 32 envisages certain things, certain conditions within the contract. Now, considering section 32 of the Contracts Act deal with contracts contingent on an event happening. Contingent contract to do or not to do anything, if an uncertain future event happens, cannot be enforced unless and until that event takes place. Contingent contracts are also not to be confused with section 56. For example, it says that if an uncertain future event happens or does not happen, then the contracts are not executable and they are voidable. It can be avoided. They are not void, they are voidable. So this is one of the essential differences between 56 and 32. Now let us take a few illustrations in section 32. 32, a few illustrations. A makes a contract with B to buy B's horse if A survives. A survives C. That is, A makes a contract with B to buy a horse, that is B's horse, if A survives C. This contract cannot be enforced by law unless and until C dies in A's lifetime. So this is a contingent contract which depends on the life or an happening of a future event. Similarly, A enters into a contract to sell a horse to B at a specific price. If C, to whom the offer is given first, refuses to buy, the contract cannot be enforced by law unless and until C refuses to buy the horse. So these are all called contingent contracts, which are all envisaged within the contract itself. That is, you make a condition within the contract, then it becomes a contingent contract. If there are conditions outside the contract, it becomes a frustrating contract. That is the doctrine of frustration. So these are basically the essentials of section 52, 56, and section 32. Now, what are the tests determining the doctrine of frustration? What are the tests you apply for determining the doctrine of frustration under section 56? There are three conditions. Basically, there are three conditions. One, there must be a subsisting contract. Two, some part of the contract is still to be performed. That is, there is a part performance of the contract. So the balance of the contract needs to be performed, and due to some supervailing circumstances outside the contract, the person is not able to perform the contract. Three, the performance becomes impossible after the contract is entered into. Physical impossibility is not a prerequisite, as already discussed. So a radical change in the fundamental assumption on the basis on which the contract was entered into is required to make the performance impracticable, illegal, or impossible without the default of either of the parties. Please underline that. It is without the default of either of the parties, it becomes impracticable, illegal, or impossible. So when you are viewing this as a party to the contract, the determination or the change in the obligation must be done while looking into the construction of the contract in the light of the facts or the time when the contract was executed. That is, you are envisaging so many things in a contract. Suppose things are, or the factors which you do not take into consideration, or which is impossible of taking into consideration, happens, then the contract becomes frustrated. Now, the test for frustration is an objective test and not a subjective test. So it is well settled that the supervening frustrating event immediately puts an end to the agreement, independently of the violation of the parties, without either party being conscious of the fact. They are not conscious of the fact that those things, certain factors can happen which is beyond their comprehension. They do not envisage all these things. Even while constructing a contract, or while you are writing a contract, the effect of the changed circumstances on the parties' contractual obligations, the intention of the parties, and the demands of justice will have to be taken into account. Similarly, in the case of the Supreme Court, in one of the cases, I'm going to quote a number of decisions, and one of the important decisions is called the Energy Watchdog 2017 14 SEC. I will be circulating the decisions also, where they brought a new approach to the contract of frustration called the multifactorial approach, which was enunciated in the celebrated English case of Sea Angel. Sea Angel was in 2013 All England Reporter, and based on that decision, the Supreme Court pronounced a decision in Energy Watchdog case. In Sea Angel, for the first time, the concept of multi-rational approach, multifactorial approach was adopted by the English courts. And in that case, the English courts held the application of the doctrine of frustration requires a multifactorial approach. And among the factors which have to be considered, what are the factors to be considered? Are the terms of the contract itself, its matrix or context, the parties' knowledge, expectations, assumptions, and contemplations in particular as to the risk that is involved in executing the contract. And so far as they can be ascribed mutually and objectively, and when the nature of the supervening event and the parties' reasonable and objectivity ascertainable, calculations as to the possibilities of future performance in the new circumstances will have to be taken into consideration while assessing whether the contract is frustrated or not. Since the subject matter of the contract of doctrine of frustration is the contract itself, and the contracts are about the allocation of risk, and since the allocation and assumption of risk is not simply a matter of express or implied provision, but may also depend on less easily defined matters such as the contemplation of the parties, the application of doctrine can often be a difficult one. In such circumstances, the test of radically different is important. It tells us that the doctrine is not to be lightly invoked. A mere incidence of expense or delay is not sufficient to treat the contract as frustrated. Hence, the factors mentioned in the above point towards emphasizes on the contemplation of the parties before entering into the contract or while entering into the contract, and while providing for the various factors or conditions in the contract. So hence, from a basic concept of frustration, now we have come to a radical or multifactorial approach to determine the frustration. The requirement of a radical change in obligation further ensures that the doctrine is not to be invoked lightly to discharge the performance of the contract. So this is very, very important while assessing or while deciding whether a contract is frustrated or not. So this particular decision, the Sea Angel's decision, which is reported in 2013 All England Reports, was the basis for the Supreme Court to decide the doctrine of frustration in Energy Watchdog case. Now, this is now the present concept of the courts while deciding whether a contract is frustrated or not. Now, coming to the differentiating section of 32 and 56 of the Contract Act. What are the differences between these two sections, which can be easily mixed and it can be confused between 32 and 56? What are the factors influencing 32, invoking 32 of the Contract Act? What are the factors for invoking 56 of the Contract Act? Under the Contract Act, section 32 and 56 apply to cases of frustration. Prima facie, both apply to the cases of frustration of contracts, and hence it is very important to note the minute or the subtle differences between these two sections. The parties may see the parties can try to shift to 56 while invoking 32, because 56 provides for compensation for certain non-performances of the contract, which for which they take a defense under 56, saying that it is a frustration of contract. See, the compensation, if the promisor knows certain things to prevail, which the promisee does not know, and as a result of which the promisor takes a defense under the doctrine of frustration, the court has very clearly held that you have to compensate the promisee because he is not aware of what the situation was and you are aware what the situation is. So, in these two circumstances, many of the parties to the contract try to shift from 32 to 56 only to get a compensation for the non-performance. So, this is the basic difference. Now, the incentive is the compensation under the third paragraph of 56, which I read to you, that a loss incurring party may receive for loss through non-performance of an act known to be impossible or unlawful. Technically, both sections 32 and 56 of the contracts can be discharged on the impossibility of certain events in the future. So, section 32 deals with contingent contract, which is dependent on the fulfillment of a condition for its survival. A contingent contract will dissolve under its own force if the condition is not satisfied, whereas 56 is attracted when a contract becomes impossible to perform because of some outside force. So, this is very, very important. So, when you are envisaging a contingent contract, the conditions which have to be fulfilled is within the contract itself. Whereas in a frustration of a contract, the conditions are beyond the scope of the contract or which was not envisaged by the parties entering into the contract. So these are the two conditions, these are the two essential differences between section 32 and section 30 and 56. Now, so it can therefore be said that it is sometimes a matter of doubt whether a contract falls under section 32 or section 56. So how do you distinguish whether a contract falls under 32 or section 56? Now, in the Supreme Court in Satya Bharat, reported in 1954, Satya Brata, that is one of the earliest cases, have very clearly held, that is 1954, have clearly held and gave a lot of clarity to the two provisions of the Act, that is 32 and 56. The Supreme Court said, in cases, I'm reading from the Supreme Court extract, in cases therefore, where the court gathers as a matter of construction that the contract itself contained impliedly or expressly a term according to which it would stand discharged on the happening of certain circumstances, the dissolution of the contract would take place under the terms of the contract itself, and such cases would be outside the purview of section 56 altogether. Although in English law, these cases are treated as cases of frustration, in India, they would be dealt with under section 32 of the Contract Act, which deals with contingent contracts or similar other provisions contained in the Act. So, Supreme Court first gave clarity to these two concepts of section 32 and section 56, where they are very clearly held. If circumstances are contingent or if they are envisaged on the contract itself, it is 32. If it is outside the contract, it is 56. So this is how they clearly made a clarity to the provisions of section 32 and section 56. Section 32 will not apply to a contract that expressly provides a condition on which performance is dependent, but also to a contract where such condition is implied. So section 32 will not only apply to a contract that expressly provided a condition, but also there is an implied condition which is envisaged by the parties in the contract, to the contract. For instance, the contract for supply of a sale of a property would be a contingent contract if the sale is impliedly dependent upon the consent of the other joint owners who are also owners of the property. That's a joint property. So when you are selling a property, there is a contingency that all the owners of the property should give consent for the sale. If not, it is maybe it is a voidable contract or it becomes unexecutable. So hence, or even if, for example, if the sale of a property depends on a condition regarding a government approval, and if the government approval is not obtained, then the contract becomes voidable. So these are some of the examples of a contingent contract. If you take 56, thus it would imply that even if a condition is implied in nature, the non-fulfillment should attract the application of section 32 and not section 56. For instance, where acquiring permission was impliedly required to sell the property, the Supreme Court scrutinized the case under section 56. It directed the respondent to approach the competent authority for its permission and stated that unless the competent authorities refuse to give permission, it cannot be governed under section 56 of the Act. Hence, if the permission is not obtained, only then it comes under the doctrine of frustration. That was one of the cases which the Supreme Court very clearly distinguished section 32 and 56. The Supreme Court also said that cases should properly fall within the scope of section 32 and not section 56, because in such cases, the contract is discharged by the non-fulfillment of the condition on which the contract was contingent and not by some outer force. Under the English law, these cases were also treated as cases of frustration because the concept of contingent contracts is not available under the English law. And hence, everything was brought under section 56 of the Frustration Act. So this is the distinction between the Indian law and the English law. So this is the basis of this is that if you are the conditions which are on which it is dependent for executing the contract, it is a contingent contract. If it is outside the scope of the contract, it is a frustration contract. The factors amounting to the frustration of a contract will have to be seen from the facts of each case. For example, the physical destruction of the subject matter. Suppose there is a building which is destroyed, then the loss of object, subsequent illegality to perform, delay, death, or incapacity of the party in a contract requiring personal performance are some of the factors that attract the provisions of section 56. So, physical destruction, illegality to perform, delay, death, or incapacity of the party in a contract requiring personal performance are some of the factors that attract the provisions of section 56. An event may fall under one or more of such factors, and some of the most common and prominent factors which determine the doctrine of frustration are as follows. 1. When the subject matter of the contract is physically destroyed. The destruction of the specific subject matter essential for the performance of the contract will render the contract frustrated. The landmark case one of the earliest cases was Caldwell case, which laid the foundation of the doctrine in the UK, also falls under the said category of frustration. This factor is strongly considered in cases where a property or a factory is destroyed by fire, and hence they were unable to execute certain orders given by the other party. Similarly, in Appleby versus Myers, reported in 1867, LR 2 CP 651, where the wall of a cinema was collapsed by heavy rain and the contract stood frustrated. Similarly, in VL Narsu Iyer versus PSV Iyer, AR 1953, Madras 300, if the subject matter is not completely destroyed, but immensely, that is substantially, even then the contract may be discharged. Suppose if the entire property is not destroyed, but a substantial portion of the property is destroyed, then the contract will be discharged. Similarly, it was held in the case where a cargo containing the dates was sold in the market for other purposes, yet it lost its mercantile character when the ship carrying it sank and it was affected by water. Therefore, the cargo owner's liability to pay the freight was discharged. This was Union of India versus Customs and Central Excise Steel Commission, 2010 254 ELT 647. That is a decision of the Bombay High Court, where a substantial portion of the cargo was destroyed, so they were discharged from paying the freight charges. So these are some of the instances where, when the physical uh, uh, the property was physically destroyed, the contract becomes discharged. Then the second is, the other aspect which should be taken is that one of the factors that should be considered, the things which are destroyed must specifically be the subject matter of the contract. It should not be incidental to the contract, but should be the subject matter of the contract. If the contract was not restricted to specific goods, then the contract will not be discharged. It should refer to specific goods, because it becomes impossible of performance when the contract is becomes impossible to perform. A contract of agency to sell goods manufactured by the defendant was not frustrated when the factory was burned down, because the contract did not restrict to the goods manufactured by the defendant at that particular factory. So there is a small distinction. Suppose certain goods are to be manufactured by a factory, and those goods are destroyed by fire, then we'll have to see the surrounding circumstances to find out whether the contract was frustrated or not. Suppose the goods was burnt, or the goods which were supposed to be supplied from a particular factory could not be supplied because the factory was burned, it cannot automatically discharge the person from the contract, because the contract was not restricted to the goods manufactured in that factory alone. So hence the court held that the concerned person who was to supply the goods will not be discharged because of this particular incident. So this is how a distinction is being made. Now, secondly, legal changes in subsequent, which leads to subsequent illegality, is one of the factors governing the frustration of contract. It is presumed that the parties to a contract should be bound by the laws existing at the time when the contract is made. However, if the laws of the countries change, which makes the contract impossible to perform, then the contract stands discharged. In the instant case, the law would also include a foreign law, unless otherwise it is reflected in the contract. In the energy dock case, which is one of the landmark cases, which also gives us the guidelines for determining whether a contract is frustrated or not, the Supreme Court held that unless the contract provides otherwise, this would be true as a general statement of law. If performance of a contract is to be done in a foreign country, what law would be relevant would be the foreign law. And if the performance has become illegal under the foreign law, the contract will stand discharged. So these are the basic observations of the Supreme Court. When there is a change in the foreign law, or the contract depends on the performance of the contract depends upon the foreign law, and if that law changes, the contract stands discharged. To discharge a contract, The change in the law must be such as to strike the roots of the contract or the basis of the contract. And unless that goes to the root of the contract, you cannot suspend, it only suspends the performance and does not discharge the parties from the contract. In Rosen Mian versus Tahira Begum, reported in 2007 Supreme Court 288, where there is a change of law which goes to the root of the contract, a mere a superficial change which does not go to the root will only suspend the performance but does not discharge the parties of the contract. In this particular case, a change in law may be brought about by the Supreme Court's order which prohibited stone crushing activity, and as per the contract, the supplier was required to supply crushed stones to from its own quarry. The change in the legal position because of the Supreme Court's order would make it impossible to supply crushed stones. So this is one of the reasons Supreme Court held, when by our own order, when there is a change of law, which the parties did not envisage at the time of entering into a contract, then this contract stands discharged. The government then similarly in New Delhi Municipal Council versus Manohar stone crushing, this is what I read, the change of law brought by the Supreme Court's order made the contract impossible. Similarly, the government import control order of 1955 put a positive condition not to sell imported goods. Hence, it was impossible for appellant to supply chicory of a specific type to the respondents because they were importing chicory to supply to the person who is making the coffee powder. Further, any prohibition order of the government which makes the performance illegal will also frustrate the contract. So this is some of the reasons which make the contract, due to the change of law, making it frustrated so that the parties cannot perform the contract. Another instance is the commencement of the Constitution also frustrated contracts which were in contravention to any article in the Constitution. A contract provides a monopoly of manufacturing radios and other electronic apparatus was frustrated by operation of Article 19(1)(g) of the Constitution. This case, Hamara Radio and General Industries Limited Company versus State of Rajasthan, AR 1964 Rajasthan 205, struck down that contract becomes frustrated because of the introduction of the Constitution which prohibits monopoly in radios. Similarly, the merging of different states. Suppose we had the 1955, the States Reorganization Act, which merged various states. Previously, Andhra was a part of Tamil Nadu or Madras at that time. Because of the reorganization of states, there was a bifurcation of the states. Then there were certain states merging into a particular state. Because of this, some of the contracts got frustrated and could not be performed because of the changed legal position. State of Rajasthan versus Madan Swarup, AR 1960 Rajasthan 138. These are some of the cases which made the contracts frustrated. Similarly, a legislation brought by the government which fundamentally changes the legal situation renders the performance illegal. In Rajkumar Gupta versus Deshraj, AR 1995 Himachal Pradesh, they said that a change in the state legislation made certain contracts frustrated. Because of the changed legal position, it was very difficult to execute the contract. However, the Supreme Court in a case decided that the liability of now we come to the banking sector, the liability of a guarantor to pay on default of the principal debtor will survive even after the Nationalization Act came into force and the principal debtor is nationalized. Industrial Corporation of India Limited versus Cananore Spinning and Weaving Mills, AR 2002 Supreme Court 1841. It held that the contract of guarantee has no correlation with that of the Nationalization Act neither is dependent thereon. It is an independent contract, and in all fairness has to be honored to fulfill the contractual obligation between the surety and the creditor. So this was one of the landmark judgments which held that nationalization of banks had nothing to do with the contract of guarantee. Similarly, the declaration of war also alters the legal relationships of the countries, and the contracts are affected when parties come from various countries and there is a war between the countries. The contracts become frustrated. But in certain situations where the continuance of those executory contracts are not against public policy, and where one party is not abrogated merely because of certain alien invasions. In HG, in Chitty contracts, it was very clearly held certain conditions can also become contingency. That is, the performance gets suspended and they don't get frustrated. 3 is in another case where the Privy Council clearly held in Overseas Trading Company Limited versus Uganda Sugar Factory, AR 1945 Privy Council, that is prior to independence 144. If the contract did not specify the source of goods, then the seller cannot take the defense that since the goods were to come from Germany, an enemy country, the contract stands frustrated, because there is nothing in the contract to show that these products should be only from a particular country. It only says we want so many tons of sugar. It can be from anywhere. So the parties cannot interpret and say that since I am not able to get the sugar from Germany, the contract gets frustrated. So this is one of the reasons where the Privy Council makes a distinction between goods in general and goods from a particular country. Moreover, a temporary restriction, like say imposed by war, according to the terms of the contract, may not result in frustrating the contract. That is in the case of VL Narasu versus PSV Iyer, AR 1953 Madras 300. As in the case, similarly, in the case of a 99-year-old lease, is not frustrated by restrictions imposed during the war, because that's a 99-year-old lease, and only the war is for about 10 years in between. The performance gets suspended but not frustrated. That was decided in Kesari Chand versus Governor General in Council 1949 ILR Nagpur 718. So these are some of the landmark judgments which decided when there is an alteration in the legal position, if contracts gets suspended or contract gets frustrated. Now coming to the third aspect, that is the loss of object. As already explained, the term impossible has not been used in section 56 of the Act in the sense of a physical or a literal impossibility. The performance of a contract may be possible to carry out certain conditions of the contract, but it has become redundant. Sometimes it becomes redundant having regard to the object and purpose of the parties by an untoward incident or an incident which was never expected. In Rozan Mian versus Tahira Begum, because of the law preventing crushing of stones, the contract became frustrated. The judgment, or the landmark judgment in Krell versus Henry, which I cited, which was one of the basis for the contract of frustration, where though the room could be hired, yet the court held that the contract is frustrated because on that particular day there was no procession which took place, and hence the tenant did not pay the balance money to the landlord. Similarly, the court will not accept the plea of impossibility if even after the supervening event, the object of the contract is not rendered redundant. Suppose an event happens and that event does not prevent the performance of the contract, then in that cases, courts have held you cannot plead frustration, since the very purpose or the object or the purpose for which the contract is to be performed is very much available. So this is how the frustration of contract was interpreted by various courts at depending on the various situations. See, you can't have a blanket rule for all situations. Now, next is delay, death, or incapacity to perform is one of the reasons quoted for frustration of the contract. In these situations, the delay and latches also result in frustration of the contract. Though it is often a difficult matter to decide whether a contract has been frustrated by an event or change in circumstances which causes an unexpected delay in its performance. The delay has to be so great so that the very character of the contract is defeated. Now, let us take a situation whether every delay leads to frustration or it is only certain delays which is beyond the control of the parties which leads to frustration of the contract. In certain cases, when the delay is abnormal, where it is beyond the scope or it is impossible to explain the delay, then the contract gets frustrated. Suppose it is a temporary delay where you can overcome and still perform the contract is perfect and it is not frustrated. Now, in the fulfillment of the obligations, when the delay is over, will not accomplish the object which both the parties to the contract had in view and for which they entered into the contract. Such a delay will radically change the circumstances, and then it will become impossible to fulfill the obligations which the parties originally had. Now, let us take a situation. If the delay was within the commercial risks undertaken by the parties and it does not frustrate the commercial purpose of the contract, there can be no frustration. In a case, delay in supply of cargo did not frustrate the contract or the terms of the contract, such a delay was already contemplated and hence you cannot plead frustration. In Reardon Smith Line Limited versus Ministry of Agriculture, Fisheries and Food, 1961 to All England Reporter 577, where they said the delay in supply will not frustrate the contract because it is still, the commercial purpose is still valid and can be executed. So this is how the courts interpreted the doctrine of frustration under this particular heading. When a contract specifically lays down a time limit, then a supervening event causing delay for an indefinite period may make the performance impossible. So this is also when a time limit is fixed in the contract, and if the parties are not able to fulfill, then the contract becomes impossible for performance. Codelpha Construction Private Limited was a State Railway Authority of New South Wales. 1982 149 CLR explains the situation which I have now cited. Now, coming to the theory of radical change in the obligation also comes into play to determine whether the delay already suffered and the prospects of a further delay from that cause will make the ultimate performance radically different. So, when you are already entered into a contract and there is a delay and the parties envisage a further delay of performance of the contract, then what is the situation? In Pioneer Shipping Limited versus BTP Dioxide Limited, 1982 appeal cases 724, it was a question of degree whether the effect of delay suffered and likely to be suffered will be such as to frustrate the commercial purpose of the venture. So this is the basis on which you decide whether a contract is frustrated or not. Finally, death or incapacity of a party whose personal performance was required as per the contract is a valid ground for frustration of a contract. In Balwinder Singh versus State of Punjab, reported in 2017, 185 PLR 356, when a person who dies or who becomes incapacitated, which prevents the contract being performed, then it leads to a frustration of contract. For example, in the English case, the contract was declared frustrated because of the illness of a party who was supposed to give a musical performance. The contract was declared as frustrated. Or it is in Robinson versus Davison, 1871 LR 6 EXCH 269. So this is one of the judgments, which was one of the earliest judgments, which said that if the personal performance is thwarted or it is not in a position to perform, then the contracts becomes frustrated. Now let us take what is the current scenario as far as India is concerned. Now we have come to a COVID situation where let us examine certain cases where when a lockdown has been declared for the entire nation and the local and state governments have imposed 144 CRPC. What is the situation when there is a social distancing, and what is the impact under the Disaster Management Act and the Epidemics Act, which where there are curfews and social distancing. In these circumstances, we also want to have a look at the force majeure clause. A force majeure clause is normally introduced in contracts where an act of God is one of the events or a force majeure which determines the performance of the contract. Now let us take a Supreme Court has taken several drastic measures, including partial closing of the courts with hearings to be conducted by video conferencing. Now let us take some of the incidents. The intervening COVID-19 and the resultant shutdown will be regarded as a force majeure event for all the agreements, and hence permitting the parties to claim impossibility of performance is naturally the course of action. Generally, most contracts have a force majeure clause. An inclusive definition is normally given to a force majeure clause, like war, hostilities, invasion, act of foreign rebellion, terrorism, etc. Then it also talks about national catastrophes such as earthquake, hurricane, typhoon, or volcanic activity. Pandemic or epidemic is normally not found in these definitions. In fact, I think for the first time, the concept of COVID was introduced as an act of God when certain contracts could not be performed and it was not envisaged in the contract itself. So this would mean that events mentioned therein are not exhaustive and would generally expand the definition to include other events also. In this regard, I would take support of judgments of the Supreme Court of India, which has laid down that the word include would enlarge the scope of the term force majeure. And this can be seen in several cases, like the Municipal Corporation of Greater Bombay versus Indian Oil Corporation, 1991, Supplement 2, SEC 18. ESI Corporation versus Highland Coffee Works, reported in 1991, 3 SEC 617. Then Oswald Fats and Oils Limited versus Commissioner Administration, reported in 2010, 4 SEC 728. Then you have the NDP Nambudiri Path versus Union of India, reported in 2007, 4 SEC 502. Then we have CTO versus Rajasthan Taxchem Limited, reported in 2007, 3 SEC 124. Associated Income Mechanical Private Limited versus WB Small Industries Development Corporation, reported in 2007, 3 SCC 607, and finally Mamta Surgical Cotton Enterprises versus Industries versus Commissioner Anti-Evasion reported in 2014, 4 SCC 87. Therefore, if pandemics or epidemic is not specifically found place in the definition clause, it can be reasonably construed that pandemic of a grave nature like COVID will fall within the force majeure clause. So it is an inclusive, it's an exhaustive definition which also includes certain factors which are beyond the scope of these parties to be included under force majeure, and if these conditions are prevailing at that time, then the contract can be invoked or the contract stands frustrated, and the courts will interpret that the contracts are frustrated under section 56 of the Contract Act. Now, some of the cases relating to COVID-19 are very important. The Bombay High Court in Rural Fair Price Wholesale Limited versus an IDBI Trusteeship Services Limited and others. It was decided on 3rd April 2020, where the Bombay High Court recognized the market situation pursuant to COVID-19 and observed that the share market had collapsed due to COVID-19, and therefore it was a fit case to restrain the bank from acting upon the sale notices and a direction to withdraw any pending sale orders for the pledged shares. So this was one of the decisions of the Bombay High Court during COVID-19. The second is an order passed on 8th April 2020. In a departure to its 3rd April 2020 order, the Bombay High Court refused to grant interim measures. In certain cases, they refused to grant interim measures to the petitioner, observing that the commodity in question was an essential item and lockdown is only for a limited period. Consequently, the petitioner cannot back out of its contractual obligations of making payments to the respondents. Where it held, there are no restrictions on its movements and all ports and port-related activities, including the movement of vehicles and manpower, operations of container freight station and warehouses, and offices of custom house agents. The notification of the Director General of Shipping, Bombay, states that there would be no container detention charges on import and export shipments during the lockdown period. So, considering these facts, the Bombay High Court refused to interfere and said that the lockdown cannot be used as a ruse for non-performance of the contract. So these are some of the laws laid down. Similarly, Delhi High Court in Halliburton Offshore Services versus Vedanta Limited, 20th April, the case pertained to restrain the invocation of a bank guarantee. While granting interim relief on the invocation of bank guarantees, the Delhi High Court observed that the country there was a wide lockdown, prima facie, in the nature of force majeure. Therefore, it would be that special equities do exist as would justify the grant of prayer to stay the invocation of the bank guarantee. Similarly, in Indrajit Power Private Limited versus Union of India, the Delhi High Court, the petitioner sought interdiction of a bank guarantee inter alia the COVID-19, where the court, while observing the petitioner's conduct, despite the extension of 12 months, could not fulfill its obligations under the contract, refused to grant relief to the petitioner. So the conduct of the petitioner also plays an important role in deciding whether the court should come to the aid of the petitioner or not. So these are some of the cases. And of course, the Honorable Supreme Court in state of Uttar Pradesh versus inhuman conditions at quarantine centers and for providing better treatment to corona positive persons held as follows. Further, while again appreciating the efforts of the judges of the High Court in looking to the matter of in depth, while passing orders, we are of the opinion that the High Court should normally consider the possibility of implementation of the directions given by it. The doctrine of impossibility, in our view, would be equally applicable to court orders as well. So these are some of the important decisions which are in vogue while deciding force majeure or impossibility of performance under COVID situations. The landmark Supreme Court case, of course, is the Energy Dog versus Central Electricity Regulatory, reported in 2017, 14 SEC, page 80, where prior to the decision, it held that prior to the decision in Taylor versus Caldwell, that was reported in 1861 All England Reporter, page 24, the law in England was extremely rigid. A contract had to be performed, notwithstanding the fact that it had become impossible of performance owing to some unforeseen circumstances, and it was not the fault of either of the parties to the contract. Similarly, in Satyabrata Ghosh versus Mugniram Bangur and Company 1954 Supreme Court 310, the second paragraph of Section 56 has been adverted to, and it was stated that this is exhaustive of law as it stands in India. What was held was that the word impossible has not been used in the section in the sense of physical or literal impossibility. The performance of an act may not be literally impossible, but it may be impracticable. That's where they draw a distinction between impossible and impracticable. And it was further held that where the court finds that the contract itself, either impliedly or expressly, contains a term according to which the performance would stand discharged under certain circumstances, the dissolution of the contract would take place under the terms of the contract itself, and such cases will be dealt with under Section 32 and not Section 56 of the Contract Act. If, however, frustration is to take place, dehorse the contract, it will be governed by Section 56. So, a clear distinction was drawn between Section 32 and Section 36 by the Indian Court in 1954 Supreme Court. Similarly, in Alopi Parshad and Sons, this is Union of India, which is another landmark judgment, 1962 SCR 793, this court, after setting out Section 56 of the Contract Act, held that the Act does not enable a party to a contract to ignore the express covenants thereof and claim payment of consideration for performance of the contract at rates different from the stipulated rates on a vague plea of equity. Parties to an executable contract are often faced in the course of carrying it out with turn of events which they did not at all anticipate. For example, a wholly abnormal rise or fall in prices, which is an unexpected obstacle to execution. It was further held that the performance of a contract is never discharged merely because it becomes onerous to one of the parties. Similarly, in Naihati Jute Mills Limited versus Hayaliram Jagannath, 1968, 1 SCR 821, this court went into the English law of frustration in some detail and then cited the celebrated judgment of Satyaprata Ghosh versus Mugniram Bangur and Company. Ultimately, this court concluded that a contract is not frustrated merely because the circumstances in which it was made are altered. The courts have no general power to absolve a party from the performance of its part of the contract merely because its performance has become onerous due to some unforeseen turn of events. Similarly, in another reported judgment, Syakirlu and Company Limited versus Nobly Thor GNB 1961 2 All England Reporter 1979, the closure of Suez Canal, and despite the fact that the customary route for shipping the goods was only through the Suez Canal, it was held that the contract of sale of groundnuts in that case was not frustrated, even though it would have to be performed by an alternate mode of performance, which was much more expensive, namely that the ship would now have to go around the Cape of Good Hope, which is 3 times the distance from Hamburg to Port Sudan. The freight for such journey was also double. Despite this, the House of Lords held that even though the contract had become more onerous to perform, it was not fundamentally altered. Where performance is otherwise possible, it is clear that a mere rise in freight price would not allow one of the parties to say that the contract was discharged by impossibility of performance. This view of law was also echoed in Chitty on Contracts, where it said a raise in cost of expense has been stated not to frustrate the contract, and it was very clearly held that a mere change or a superficial change in the conditions cannot frustrate the contract. But one of the most important cases is the Sea Angel case reported in 2013, one Lloyd's Law report, which formed the basis of the Supreme Court in Energy Watchdog case. The modern approach to frustration is well put and the same read as under, where the uh, the House of Lords held, in my judgment, the application of the doctrine of frustration requires a multifactorial approach. And among the factors which have to be considered are the terms of the contract itself, its matrix, or the context, the parties' knowledge, expectations, assumptions, and contemplations, in particular, as to risk at the time the contract was entered into. So these are some of the important judgments, and which are really goes to the root of the matter as far as the doctrine of frustration is concerned. Now, the latest Supreme Court in Southeast Asia Marine versus Oil India Limited, reported in AR 2020 SC 2323, the Supreme Court held as follows. See, in India, the Contract Act had already recognized the harsh consequences of such frustration due to the pandemic and the COVID, and to some extent had provided for a limited mechanism to ameliorate this same under Section 65 of the Contract Act, and Section 65 provides as under: obligation of a person who has received advantage under a void agreement or contract that becomes void. When an agreement is discovered to be void, or when a contract becomes void, any person who has received any advantage under such an agreement or contract is bound to restore it or to make compensation for it to the person whom he has received such an advantage. The aforesaid clause provides the basis of restitution for failure of basis. We are cognizant that the aforesaid provision addresses limited circumstances wherein an agreement is void ab initio or the contract becomes substantially void. And hence they say that the factors which have to be taken into account are the force majeure clauses, where it says there's an act of God, or when there's a destruction of the property, or when there is a COVID situation. You have to address these issues under Section 56 of the Contract Act. There is another important aspect which I would like to highlight, where in Hong Kong, with one of the decisions in Hong Kong when there was a SARS epidemic, and which rendered the contract frustrated. One of the first judgments of the Indian High Court or the Madras High Court was rendered in Edmund Bennett and another versus Edgar Raffle Home, reported in AR 1925 Madras. In that judgment, the origin of force majeure was traced. The term force majeure, which is borrowed from Code Napoleon, has received interpretation in several decisions of the English courts, and Justice Bailhache in Matsokis versus Priestman and Company 1915 1 King's Bench, after considering the definition given by eminent Belgian lawyer of force majeure as meaning causes you cannot prevent and for which you are not responsible. So the first of these cases was in 1925, AR Madras 626, a division bench, traced the origin of the force majeure clause. Similarly, it also explained that if the hindrance was insurmountable, it would amount to prevention, which was another term used in the contracts, which would relieve the sellers from the liability, and the Court of Appeal held that the arbitrators were accordingly justified in finding the boilers not liable. So these are some of the cases which trace the origin of force majeure which also forms the basis for frustration of the contract. Now, the other judgment which I would like to highlight in this present situation is the uh, decision of the Hong Kong court in Li Ching Wing versus Zhuang Yu Qing, reported in 2004, 1 HKC 353, popularly known as the SARS case. In that case, the plaintiff was registered owner of a flat in Block E in Kowloon, and he let the premises to the defendant for domestic purpose for a fixed period of 5 years, beginning from 1st August 2002. So in March 2003, many residents were infected with severe acute respiratory syndrome, popularly known as SARS. And fearing of being infected, the defendant moved out of the premises and stayed in another place. And subsequently, the block where he was residing in Block E was isolated for 10 days by the government, and the residents of E block were evacuated to various other places because the entire apartment was infected by SARS. Then subsequently they were allowed to return to their flats afterwards, after the SARS syndrome came down, or it was relatively less infective. The defendant also returned to the premises, and he sent a letter to the plaintiff to terminate the tenancy agreement, and he was willing to waive his rental deposit as compensation to the plaintiff. The plaintiff wrote back to accept the alleged wrongful repudiation of contract. So he then commenced proceedings in the court for accrued rent and damages arising out of the repudiation. The main defense of the tenant was that the tenancy agreement was frustrated by making the isolation order due to SARS. He had other defenses also, which were not concerned with the purposes of this article. The court, after considering the submission, favored the plaintiff on the following grounds and laid as follows. The frustration of a contract took place when the performance of the contract was interrupted by a supervening event which so significantly changed the nature of the outstanding contractual and obligations. But what was supervening event was ultimately a qualitative question. What relation does the likely period of interruption bear to the outstanding period for performance? So this was one of the reasons where they said you cannot repudiate the contract because it was only for a temporary period and the contract is still performable. Now coming to the conclusion part, the following factors will have to be considered while rendering the contract as frustrated. They are: the words of the contract should be looked into, that is, the definition of force majeure is important. 2, it must proceed from a cause not brought about by the defaulting party's default. 3, the hindrance caused must be such that it is impossible to perform the event which is beyond the party's control. 4, that no reasonable steps that could have been taken to avoid or mitigate the event or its consequences. 5, must have been brought to the notice of the other party. The same situation should have been brought to the notice of the other party. 6, the party seeking to rely on the clause may also need to show that he was not aware at the time of entering into the contract that the circumstances giving rise to the event of force majeure was likely to occur. So based on these factors, a court should decide, or court will decide, whether a contract is frustrated or not. So these are the basic things while evaluating whether a contract is frustrated under section 56 of the Contract Act.